Good morning. You may proceed. Please place this on the record. You may proceed.
Today is the 10th of September 2025 in the Magistrate's Court sitting in the evening at our STD in the matter between Manuel Mulunga and 14 others. Before court is accused number 2, who is the first applicant in this case, in the application case number 854 of 2025. Presiding officer is Muharukua for the state, Lungu, and for the accused, Mr. Isaacs, assisted by Mr. Cupido and Ms. Inge, and matter before this court for the continuation of the bail application, and we are ready to proceed.
Ladies and gentlemen, I do confirm my appearance of the applicant is that we are ready to proceed.
You may proceed. Applicant, take note that you're still under oath. You may proceed.
Good morning, Mr. Willemse. Mr. Willemse, I can't hear you.
Good morning.
Thank you. So, just to round off this testimony, the credit limit, is it monthly or yearly?
It's
Monthly, thank you. So, the next aspect that I want to deal with is in regard to the asset acquisition. As I said, indicated, Your Worship, it deals with count 11B, alternative to count 11, this is the last part, count 12, count 13A, alternative to count 13, and then count 16. Those counts, take their counts in consideration when we deal with the specific aspect. Mr. Willemse, you testified yesterday that there was an agreement that gave birth to asset acquisition.
That is correct, Your Worship.
Which agreement was that you referred to?
That is the fuel supply agreement entered between NAMCOR trading and distribution and NAMCOR, PPYLTD.
Which is not to refer the court to page 159 of second one. Thank you, Worship. Mr. Willemse, can you please identify the document that I just referred to the court to?
This is the fuel supply agreement, if I can read, entered into by and between NAMCOR Petroleum Trading and Distribution PYLTD, a company incorporated under the laws of the Republic of Namibia with registration number 2000/4/421 with registered office. Petroleum House 1 Aviation Republic of Namibia. That is the cell. And then, of course,
Just proceed.
and Namibia PYLTD, a company incorporated under the laws of Namibia with registration number 2009/4/0110, having principal place for business at office suite number 16, Pasteur Street, City View Building, window base Namibia, here and after referred to as the high.
Right. So if you go to page 182, you will find parties that signed this agreement. Page 182, Worship.
That is correct. Your Worship, that is correct.
On the respect of NAMCOR Namibia to sign on NAMCOR Namibia's behalf.
Peter Anu Ilindi, designation is chairman.
And
Rebecca
just wait. I'm just asking who's the representative. I believe Rebecca is a witness.
Oh, yes.
Right. And when was this signed?
I believe it was on 16th day of March 2022.
That's not a belief, it's just indicated when the document
It's
is
executed in Binduk on the 16th day of March 2022, Your Worship.
right. And who signed on behalf of NAMCOR?
That is Emmanuel Mlunga, designation managing director.
Right. So this agreement, when it was entered into, where were you employed?
I was employed at NAMCOR as a consultant and had no dealings with any of this matter. I wasn't even aware of this agreement at that point in time.
You then testified that it gave birth to the asset acquisition. Can you go to clause or page 164, clause 4.5.1?
There, Your Worship.
You may proceed.
Thank you. So can you just read that into the record, please?
4.5, the heading is bias equipment. And then it moves to 4.5.1, which is the relevant paragraph that's identified. It says the seller and buyer to enter into negotiations with respect to the purchase of all assets, open bracket, arms, canopy and tanks and related equipment belonging to the buyer, hereinafter referred to as equipment, at the market-related value to be established by the parties, joint technical team. The parties further agreed to negotiate within a reasonable time an amount that could be set off against the debt owned by the buyer, open brackets, if any, close brackets, at the time of negotiations with regards to the acquisition of the equipment.
In other words, if I understand correctly, there was an agreement, first of all, that at some point buy the assets of the buyer. And the buyer here is?
The buyer here is NAMCOR trading.
There's also a second part of this paragraph that says that if the money is paid, that some of the debt will be extinguished from the payment. Correct?
Yes, that is correct.
Now, under which department would a acquisition of asset fall?
Sales and marketing department, as explained to the board yesterday.
Alright. As far as my man served me, you said you're not part of that team.
No, it's a different business unit within the NAMCOR trading department, which consisted of the 2 units.
Were you at any point involved in the agreement, the acquisition agreement between NAMCOR and NAMCOR?
The asset acquisition.
That's correct.
Yes, I had limited involvement when I joined in June 2022.
Alright. I want you to go to, or rather, may I refer the court to page 253.
Before you proceed, you said you had limited involvement. What is that limited involvement you are referring to?
I'm sure.
Are you still delving into it?
Yes. I'm going to the court to have a reference to which asset agreement I'm referring to.
All right,
Page 253.
Yes.
Thank you, Worship. Mr. Willemse, on page 253 of bundle 2, please identify the document in front of you.
Your Worship, this is the asset purchase agreement between NAMCOR Petroleum Trading and Distribution and Energon Namibia Pty Ltd.
Alright. Now, you testified that your involvement in this is limited.
That is correct.
Can you explain that, please?
Okay. Your Worship, just to clarify, with regards to the fuel supply agreement, I had no involvement, which gave birth
to the asset purchase agreement as per terms as per clause 4.5.1 in the fuel supply agreement. However, in the asset purchase agreement, I was asked by the managing director just before I on board in a substantive capacity on 1st of June.
I would like you to please repeat that maybe a little bit slower.
Mr. Willemse has already indicated we are taking notes. I know you want to express as fast as possible your evidence, but we are taking notes, just take it slow.
So with regard to the asset purchase, you are not involved?
I am limited involvement due to the fact that in May 2022 of that year, I was asked by the managing director, Mr. Memo, that due to my vast experience in the industry and experience with some of the projects, to assist the sales and marketing team by providing advice and in some instances just to make sure that everything and I was just there to ensure that the deal is all the I's, as they say, are dotted and the T's are crossed.
Just wait. Who was the team that was tasked to facilitate this deal and being therefore instrumental in the conclusion of this agreement?
The project owners of this deal, Your Worship, was the sales and marketing team. Worship.
You can proceed from there.
In conjunction with his commercial manager, Ms. Olivia Tunaiski.
Is Ms. Olivia Tunaiski an accused in this matter?
Yes, Your Worship, accused number 4.
Yes. Proceed.
So that was on request from the MD due to my expertise, because of he wants in all the MD had the approach of ensuring that the team, that I am an executive in my role, but as per my expertise that you guide and assist where necessary. So he employs, or in his discretion, is the team that can assist, or someone that can assist the team if necessary. In this case, if he deemed it fit to ask me to just have some kind of a advisory role in this matter, although he cautioned me that it's not my duty to be part of this, and I shouldn't make any decisions because this is the role of the sales and marketing team.
Mr. Willemse, you are dropping your voice.
Okay, thank you. He advised me that I just need to advise the team where necessary.
Okay. Now, the team you said consists of David Maposa, Olivia Tunaiski. Is that the only people that were involved in this?
Correct. You would if I refer back to the fuel supply agreement, Your Worship, clause 4.5.1 make reference to a joint technical team.
Okay. Who's this technical team from NAMCOR side?
Your Worship, at the time when I was approached, there was already, I think in mid-May 2022, he already instructed the executive engineering and technical services to conduct an asset valuation
In mid-May of which year?
May 2022, mid-May 2022. He instructed the executive, engineering and technical services Mr. Nestor Shifeni.
Just wait. Mr. Nestor Shifeni.
Correct, Your Worship.
Is he an accused in this trial?
No, Your Worship.
Rather charges. You proceed from there.
As well as the engineering manager, Mr. Michael Aikunda.
Pause there. Is Mr. Michael Aipanda an accused before court?
No, Your Worship.
May proceed.
To conduct the asset verification and valuation exercise of the assets in question, which are pump, tanks, canopies, and related equipment, which we also refer to in the industry as bulk fuel storage facilities.
Without the verification of the asset, is the purchase of that asset possible?
No, Your Worship. You have, in the industry, you have to verify if the assets do exist, number one. Number two, in what condition the assets is. Because the assets has also got a lifespan. As well as what the value of the asset is.
All right. So you first have to determine, as you say, whether the asset exists
Correct, Your Worship.
and whether the asset belongs to the person.
That was not part of their duty. That would be later part of the due diligence duty, of which is in the legal and the sales and market. Actually falls within the legal department's framework.
All right. So we also have, according to you, a legal team that must make sure that the property or asset to be acquired belong to the buyer that is selling it.
Correct, Your Worship.
All right. Was this done? Oh, before I come to that, who's fall under this department?
The legal team, the head is Demolin Morocco.
The name?
Demolin Morocco.
Just pause there. Is Demelin Morocco, is it a lady?
Yes, that's
Is
correct.
she part of the charges?
No, Your Worship.
Who else?
But she tasked, actually she wasn't involved in the technical committee. She tasked the legal manager, Ms. Ilda dos Santos.
Ilda
I-L-D-A.
dos Santos.
That's correct.
Is Ilda dos Santos part of this charges?
No, Your Worship.
Now, if there was no due diligence done on the ownership, was it possible for this purchase agreement to be concluded?
No, Your Worship.
So, Mr. Willemse, what did you verify?
Your Worship, I was in my capacity, I was just giving advice and ensure that everything is done prior to the submission being submitted to the MD.
So, question, did you verify anything? Did you do due diligence? Did you draft anything? Any of those instrumental aspects of the purchase agreement?
No, Your Worship.
Okay, maybe just I don't know if you're going to ask this, but everything is done. What does everything is done mean?
I will.
Okay.
May I just take it to the
Yes.
Worship? So we have now, before the agreement, we have the verification that the asset exists.
Correct.
Then we have the legal team that makes sure that there's ownership is confirmed.
That's correct.
Due diligence.
Yeah.
What else must be done before the purchase agreement?
Your worship, then actually prior to the legal side and the due diligence comes at the back end.
Okay.
So first you do the asset valuation and verification. Then you would look, that would determine what the price should be of the assets that is to be acquired. Then you would do what we call in the industry a DCF, which is a discounted cash flow. But the fancy word is actually a project feasibility model, which is basically the same. Once
Just pause there. Yes.
Once you have done the asset valuation, asset verifications, and once the project feasibility model is done, then you would look at the outcome of the result of the project feasibility model. Then you would the task was on the sales and marketing team to then write a memo based on this.
Mr. Willemse, sorry to interrupt you there. I think we all need to understand what is this feasibility study. What is the purpose of the study? To do what?
Is to ensure that the assets, together with the volumes, or the supply volumes, is going to be profitable.
Thank you.
For NAMCOR trading at the end of the day, in conjunction with the timeline that you acquire these assets.
All right. Now, who did that?
The project feasibility model was done by Mr. Sam Hashele, the financial analyst of NAMCOR Trading. I'm not sure if it's NAMCOR Trading or NAMCOR Holdings, because the finance team was designated from the holding company to assist the trading company.
Now, Mr. Sam Ashela, is he part of the accused that is facing charges for selling or buying an asset that doesn't exist?
No, Your Worship.
Were you involved in the drafting of the contract?
No, Your Worship.
Were you involved or physically going to wherever the assets were to see if they exist?
No, Your Worship.
Were you involved in drafting the feasibility study?
No, Your Worship.
Let me give you a proposition. If someone come and testify in this bail application that you are the one that instructed or requested this Sam Ashela to compile the feasibility report, what would you say?
That's not true, Your Worship, and I will quantify that. Or qualify. That's the
Qualified.
Qualified.
Quantified means you put too much meat on the bone. It's disqualified. Yes, you may.
You see, Your Worship, when the fuel supply agreement made reference to a joint technical team. So after the valuation or the sales and marketing valuation was done, the asset verification and valuation was done by the engineering team. The sales and marketing team called a meeting with all the role players that needs to be involved, which would then comprise the committee. Or the relevant people be involved.
So the sales and marketing team held a meeting too?
They would call the meeting.
Okay.
Yeah. To discuss how to proceed in this acquisition. And the members or the team that was called was obviously the engineering and technical team, Mr. Nestor Shifeni and Mr. Michael Ipanda. They would call the financial analyst whose job would be to compile the project feasibility model. The marketing team themselves, consisting of Davis Maposa and Olivia Dunaiski, the legal manager Hilda Dos Santos, and I was also part of the meeting. And in that meeting, it was discussed that once the outcome of the verification and valuation was done, a report need to be compiled and sent to the committee.
Which committee?
This technical committee which I just mentioned,
Okay.
would form a committee. And then it was discussed in the meeting that that report need to go to sales and marketing as well as the financial analyst, Mr. Shema Shela. So I couldn't have instructed as alleged in the charge, because Mr. Shema Shela did not report to me, number one. Number two,
You could not have instructed what?
Mr. Shema Shela to compile or to do the feasibility study
Okay.
or model, project feasibility model. Number two, all input parameters you will get from the sales and marketing team. However, Mr. Shema Shela, this, I must mention to the court that this is his daily job. This is his job that NAMCOR employed him. He need to independently, without any inputs, verify the correctness of the input parameters that he's going to use in the model. Because at the end of the day, he needs to put his signature to that report.
So your answer is you didn't instruct him.
I didn't instruct him, Your Worship.
Thank you. Now, I want to refer the court to page 242. I will just mainly deal with the second one today.
The second?
Second bundle.
Okay.
Yeah.
It is noted. You may proceed.
Thank you, Your Worship. Mr. Willemse, what appears on page 242 of the second one?
It's the NAMCOR Namibia Asset Register for the fuel storage facilities and installations at MODVA sites. MODVA meaning Ministry of Defense and Veterans Affairs.
What is the significance of that document?
In the oil industry, Your Worship, an asset register is proof that you own the assets. It's not a title deed as being referred to, because this is a movable asset.
Mm-hmm.
And it's also in your books, your financial books, because when a company spends money acquiring assets, those assets get listed in what we call an asset register. And this is what it is.
So that's proof of payment in a nutshell.
No, it's not proof of payment. It's a proof that
Proof of ownership, right?
proof of ownership, correct.
All right. Can you please go to page, may I refer the court to page 253, A, capital A?
Yes.
You may proceed.
If you look at the preamble, is there anything in that document that shows or indicates who's the owner of the asset? On page 253, capital A.
It says in the second paragraph of this document, Your Worship.
Just to note that, Your Worship, this document is part of the asset sale, asset acquisition agreement. Can you read that? into the record.
Whereas Enacon is the owner of certain bulk storage facilities comprising those assets and any and all equipment used by Enacon in conjunction with the operation of said assets set forth in Exhibit B, attached hereto, open bracket, hereinafter to refer to as the assets, close brackets, and
To which assets is this preamble referring to?
the assets that NAMCOR Trading wishes to acquire.
Thank you. Now, Mr. Willemse, obviously we all do not understand the industry. What? Let me just tell the court. Why would someone buy an asset that is on someone else's property?
Okay. Your Worship, this is not new to the industry. There is many ways how you can onboard a customer and secure volumes. One of the ways is, or the simplest way, is just to enter into a fuel supply agreement without any investments in assets.
Just pause.
However, that doesn't give you exclusivity, which means if the customer owns the petroleum-related equipment, which is the assets, he can shop wherever he wants to. He can buy today at Puma, tomorrow at Total, Engine, and NAMCOR. So if his offtake is 100,000 liters, if you are lucky, today he shops with you for 20,000, tomorrow he shops at someone else for 30,000 liters.
All right, so that is one.
That is one. That is
What's
one.
the other way?
The most common in the industry, which gives you a secure security of supply, is to get exclusivity. And that is to invest into petroleum assets. Where you then invest, you as the oil company, and in this case NAMCOR Trading and Distribution, would then invest in the equipment to ensure security of supply and ensures exclusivity. Which means in this case, Your Worship, and I just want to mention, in the oil industry, downstream petroleum industry in Namibia or anywhere, every hydrocarbon molecule is important for an oil company, which is actually every fuel drop in layman's term, or every liter is important. Now, Enacon had a lucrative contract with the Ministry of Defense for 15 years, of which at the time of the fuel supply agreement, I understand, about 10 years was left, and at the time of the asset purchase agreement, about 9 years was left on that agreement. So every fuel or oil company would like to have this contract. However, Enacon had this contract to supply the ministry. NAMCOR had a strategic objective to acquire, but when we tried as NAMCOR Trading, we were told by them to approach the ministry to supply them. They said they had this long-term contract with Enacon. So for NAMCOR to go after Enacon's business would make sense. So therefore, I believe, and I say I believe because I'm not part of the sales and marketing team, but because I'm part of the executive team that meets monthly, and every department and business unit talks and presents what their plan of action is, how they intend to grow the company, how they intend to make the NAMCOR Trading profitable. this would be presented, and they had a list which they call suspects, not in the criminal sense of the word, which is a list of clients that was identified, which if it becomes viable, it turns into a list of prospects. And Enacon was on this list. So therefore, the sales and marketing team went after the Enacon business. However, they were successful apparently in 2021 when Enacon on a non-exclusive basis starts procuring fuel. But then in March 2022, they signed a fuel supply agreement with Exclusivity.
Just wait.
And also in that fuel supply agreement, they refer to the acquisition of the assets. You see, Your Worship, in March 2022, as I understand what the sales and marketing team presented in the executive meetings, that they first need to get a budget to acquire. So they inserted this clause as the phase 2 of the fuel supply agreement. It's actually a pity, Your Worship. If I was the legal team that drafted this fuel supply agreement, however, I'm not a lawyer, I would insert a clause saying to make the fuel or the asset purchase agreement part of this, but payment on a future date once budget is approved.
Mr. Willemse, let's just deal with what is on the ground now.
Are we still referring to this purchase,
Yes.
asset purchase agreement?
Correct, Your Worship.
So, let me just lead you. One way of securing business is to give you fuel.
Correct.
The second one, if you want to acquire exclusivity, you invest in tanks.
Correct.
The asset agreement, in what did it invest?
In the assets, the pump, tanks, canopies, and related equipment.
Once it is purchased, what can Enacon not do?
They cannot procure fuel from any other supplier other than NAMCOR Trading and Distribution.
As that's the exclusivity that you...
Once it is purchased, cannot?
Procure fuel from any other supplier or oil company.
So Enacon cannot buy from Total today and tomorrow from BP?
No.
Who must they buy fuel
From NAMCOR Trading and Distribution, their full volumes that they need to supply to the Ministry of Defence and Veterans Affairs. Only.
Okay. Now, I want to refer the court to page 249 of the second mandate.
If I may just say,
249.
if I may just, can we quickly just deal with on the last point that you requested or an answer, just to verify it in 256 number
250?
256, clause 2.2, 2.3, 2.4.
Clause?
2.2, 2.3, 2.4. Just to clarify to the court exactly the previous question that I answered, that it is contained in the asset purchase agreement.
You mean the exclusivity?
Yes, and the assets.
While you're there, please read 2.2.
2.2, Enacon, the worship, warrants and represents that the assets are not encumbered
Just repeat that. Repeat that wording again in 2 words.
That the assets are not encumbered
Thank you.
or subject to any lien, cession, or claims as at the effective date.
See. So, Energon told NAMCOR, there's no encumbrance on these assets.
Correct, Your Worship.
I can sell it to you.
Correct, Your Worship.
Let's go back to page 249. I must tell you, Mr. Willemse, this is the document that landed you in trouble on the various charges that I'm going to read to you. I'll deal with them, but let's first deal with this specific document. Can you tell the court, sorry, you was court with us?
Yes.
Who is the author of this document?
Ms. Olivia Donaisky, the Commercial Manager, Sales and Marketing Department.
And who did she write it to?
To Emmanuel Malunga, the Managing Director of NAMCOR Trading and Distribution.
And the date, it was the date appearing there?
8th of July 2022.
Is it correct that this is the memo that then informs the MD about the acquisition of this, of the asset?
That's correct, Your Worship.
All right. Let's see. On the second page, 250. At the conclusion, there's a request. Who's requesting it? Can you just read that into the record?
It is requested, or should I say ordered, by Olivia Donaisky, Commercial Manager.
Sorry, Mr. Willemse, just read the conclusion part.
The conclusion part. The Sales and Marketing Department herewith kindly request that the Managing Director approve the above request.
If I understand your evidence correctly, you are not Sales and Marketing Department.
That's correct, Your Worship.
And according to this document, it is the Sales and Marketing Department requesting the approval.
Correct, Your Worship.
There appeared 5 signatures on the document.
That's correct, Your Worship.
The first signature is from who? On the left.
Ordered by Olivia Donaisky, Commercial Manager.
From which department is she?
Sales and Marketing, Your Worship.
So what does ordered mean?
She basically is the author of this document, and she is the one who requests that the MD approves this request.
Okay. Then next to her signature, on the same line, what does it say?
Supported by Davis Maposa, Acting Executive, Sales and Marketing.
What does supported mean?
He supports the project after reviewing, Your Worship, before this document. Obviously, the review of the financial feasibility model was done, and the outcome of that model gives birth to this document.
So after it makes sense, the numbers make sense, this document appears.
Yes, Your Worship.
All right. But his support is what?
As the Acting Executive, Sales and Marketing, the boss of Olivia Donaisky, the Commercial Manager.
All right. So she asked for the, if you read the conclusion, asked for approval. This is done by Olivia and supported by her boss.
Yes, if I may add, in the committee meeting, this was one of the things that has been discussed, that he requested Ms. Donaisky to author or to draft this document.
Okay. Mr. David Maposa.
Davis.
That is confirmed and support that his subordinate's order or request to purchase, is he part of this trial?
No, he is not, Your Worship.
Then your name appeared.
Supported by Cedric Willemse, Acting Executive, Supply and Logistics. That's me, Your Worship.
Why did you support?
Because I was part of the committee, and I also reviewed the document or the documents that was submitted to actually concur that this project is a viable project.
Then there's, it is ordered, it's supported, then it's now recommended. Who recommended this purchase?
Recommended by Nestor Shufeni, Executive Engineering.
Mr. Shufeni recommends to the MD to purchase this station.
Correct.
This assets. Nestor Shufeni, is he your co-accused?
No, Your Worship.
The last signature to this document, who is that?
It's Mr. Emmanuel Malunga, Managing Director, and it's stated he approved by Emmanuel Malunga, Managing Director.
You're dropping it.
It's approved by Emmanuel Malunga, Managing Director.
Is he an accused?
Correct, Your Worship. Accused number 1.
First accused. Now, I want to ask you something. If your signature was absent, would the purchase go through?
Yes, it would.
If Maposa's signature were absent, would the purchase go through?
No, Your Worship.
If the commercial manager, Olivia Tunaski's signature were absent, would it go through?
No, Your Worship.
Why? Why?
Because she is the custodian together with Davis Maposa of this project. So and at the end of the day, Enacon is her customer.
Who's the boss between Maposa and Tunaski?
Maposa.
If there was an absent signature of the executive engineering department, would this document, was this asset acquisition go through?
No, Your Worship. Because these 3 individuals is instrumental in this project. Because the one verifies the assets, valued the assets, and the other ones are the ones that are the project owners of this investment or acquisition.
No.
And you are?
I was just assisting. So from a technical expertise point of view, and I will take the court through as to why I supported this acquisition.
Why did you support it?
Sorry?
Why did you support it?
If we can go, I would actually have wanted the court to, that this document need to be read in evidence because there's some information here.
It is already part of the record. Defended in.
Okay, so I can make reference to some of this at a later stage.
But here's the question that the court is asking, and what I was asking. Why did you support it?
Okay.
Simple question.
If we can go to the feasibility model.
That would be 221. Am I correct, Mr. Willemse? Is it 221?
Let me just check. I believe that is correct, Your Worship.
Bishop, I just want to find out if the court is on the page.
Yes, sir.
Which specific page, thank you, Bishop. Which specific page you want to refer to, Mr. Willemse?
Your Worship, the page number 230.
before you go into technical aspects of this, if in a nutshell, if you would tell a layperson, why did you support it, what would you say?
It's because the project and the acquisition of these assets is profitable for NAMCOR, and it will increase NAMCOR's revenue and, like I said, profit margin for the period that the assets is owned.
Okay.
Sorry, Your Worship, if we can actually start at 226.
This is part of a project feasibility model.
Correct, Your Worship.
You may proceed.
Your Worship would see under the first page, on your left-hand side, there's sales. And the second one is average sales volumes per period. So Your Worship would recall I made reference that the monthly volumes, when I said the NAMCOR had this lucrative supply contract with the Ministry of Defence, they, in their agreement with the Ministry of Defence, as well as in the fuel supply agreement, the minimum volumes they would supply is between 700,000 litres to 1 million litres per month. Whereas in the contract of NAMCOR and the Ministry of Defence and Veterans Affairs, it's stated as 12 million litres per annum, which constitutes 1 million litres per month. However, in this model, volumes that was used is 451,208 litres. This was when this was presented to the committee, the Joint Technical Committee, I actually asked, okay, this volumes, why you use 451,000? Then he said that is the minimum volume that he could pick up, because NAMCOR at some time, when they procured on an ad hoc basis from NAMCOR, sometimes at about 700,000 litres, but during a period their sales volumes dropped, and this was the minimum volumes that they were procuring from NAMCOR at that point in time.
So he took the minimum volumes?
He took the minimum volumes, which was fair, because you don't, when you project, and the argument of Mr. Ashela was, if this model passes the minimum volumes, it's good, because the volumes with NAMCOR supply of NAMCOR, we would be able to reach 700 to 1 million litres, which will make this model even more economical. So that was the first tick, Your Worship. The second input or tick which made me support this acquisition is on 230, Your Worship, page 230 of the project feasibility model. Right at the bottom, Your Worship, you would see payback 4 years.
This is page 230.
230, right at the bottom, Your Worship.
Yes, I see it.
Payback 4 years. Now, Your Worship, the NAMCOR had an agreement with the Ministry of Defence and Veteran Affairs for 15 years. And I already testified at the time of signing the fuel supply agreement. There was about 10 years left, more or less, an agreement that I was not party to. But at the time of this intended acquisition, there was about 9 years left. So you would pay back your investment or recoup your investment in 4 years.
On the minimum.
On the minimum volumes, Your Worship. That makes further sense, which means the rest of the 5 years you would just pocket. NAMCOR Trading would just collect money.
You mean profit?
Profit. What further enticed me to support this agreement or this acquisition, Your Worship, is on page 231.
To 31.
231. On that table, 1, 2, 3, the fourth from the bottom, there's a payback period in years that is 10, so which means the model was run for a period of 10 years. But just 1, 2, 3, 4. On the fifth from the bottom of that column, there is a number 1.13. $1.13.
Yes.
What is significant, that is the margin, Your Worship. The wholesale margin that NAMCOR will get.
I think
On-
that it's cut off. So
It's basically cut off, yes, Your Worship.
what
There's
is the
actually,
full word of
yeah, it's actually a dealer margin that stays there because this document is getting used for both commercial and retail transactions. But-
You said the amount is $1.
$1.13.
What is the significance of that?
It is your profit margin, not your net profit margin, your gross profit margin that the wholesaler, the oil company, in this instance NAMCOR Trading, makes on every liter sold.
Okay.
What is significant, Your Worship, is that $1.13 was the baseline and the margin at that point in time in 2022. Now on 239, page 239, Your Worship. Because one of my questions was, why to the financial analyst in that committee meeting is, why didn't you then, because the wholesale, the margins to the wholesale, the oil company and the dealer gets reviewed.
why didn't you then what? You
Sorry?
said why didn't you then?
Yes, why didn't you use increment, a projection over the 9 years of the increases that the ministry would from time to time award? The ministry would from time to time, and this ministry is the Ministry of Mines and Energy, that will review margins to the industry on as and when they feel on request from the industry for them to review.
What was his answer, Mr. Willemse?
His answer was he took a moderate approach, and on 239 I will showcase to the court the projection of increment he assumed, because this is based on assumptions. Just moderate.
Yes.
So he started off in $1.13 in year one, which is 2022. It moves to $1.19 in 2023. It moves to $1.28 in 2024. And today, in 2025, he projected that it would stand at $1.33.
Yes.
$1.33, sorry. The wholesale margin as we speak and as we stand here, Your Worship, is currently at about $2.30, which indicates to the court that the moderate approach, he took a very moderate, conservative margin increase that he projected that the Ministry of Mines would give to the industry. We cannot...
What does that in a nutshell mean?
It means that for every liter now sold,
Yes.
the 450, NAMCOR would have recovered now $230 a liter, which is basically $1 a liter more,
And how does it...
which would have made this even much more profitable.
Okay. So your profits would be much higher.
Much
if
higher.
And when this...
And your payback period would have reduced significantly, even to, because this is double, even to probably 2 years. So this investment would have paid off itself in 2 years. But the last point I want to refer to the court is on page 235 of this model.
Page 2.
35, Your Worship. Your Worship would see there is where it says payback.
Yes.
On payback, this model, it shows that it becomes positive, the numbers. The number on top is minus 661,979. Then it becomes positive 505,046. This is to justify that the project will pay itself back. NAMCOR would recoup their investment, NAMCOR Trading, in 4 years. But what is very interesting, Your Worship, if you page over to 236,
So they would recoup how much in 4 years?
their full investment of 53 million. That's why on the previous memo, I would have wanted to read it in. The purchase price for this was 53 million 212, I think. But we can refer to that memo. So the 53 million investment would have been recouped in 4 years, while we as NAMCOR Trading had 9 years left. Then on the second page, 236, Your Worship.
Let's just get clarity there. In terms of the agreement, the assets would be bought for 53 million.
Correct.
According to you, not according to you, according to the model by NAMCOR Trading, they will get the 53 million back that they paid
Correct.
in 4 years.
Correct.
And because you say recoup, let me just say, I just want to talk kind of NAMIs at some point, just that everybody must understand.
Yeah.
So
The payback period for this project,
Would
for this investment, let me say that, it's 4 years.
that is provided the volumes is minimum 400,
Correct.
and provided there is no increment.
Correct. Or moderate increment as depicted in the model. So now, Your Worship, I would like to point to where it stated 9 years in that on page 236.
Yes.
On the left-hand side of that 9 years, Your Worship would see a number 55.534,591 million. That is the additional, after you have get your payback, or not recouped, but
We can use recoup for now.
yeah. After you recouped your investment, you got your money back after 4 years. You make additional for the balance of this asset. You sweat this asset basically. You will get at 9 years 55.5 million additional. And that is based on the minimum volumes, a moderate increase in dealer margin. Now, Your Worship, if one would just now...
Just before you proceed, and this is Namibia dollar? Or?
Namibian dollar, sorry, Your Worship. It is just that the model, I think the model is pegged. I'm not sure who was the... consultant.
So you would have made a profit, 100% profit on year 9,
Correct. On year 9, 100%.
provided the volumes were as little as 400.
Yes.
There's no.
So imagine if the volumes would be the 750 to 1 million as now supplied by NAMCOR. And that was the intent. That we, as NAMCOR Trading at the time when I was there, the sales and marketing team would then increase the sales to Enercon, to the ministry, to 700 as a minimum, to 1 million as a maximum. You would have recouped and doubled this 55 would have been 100 million on top of your 53 million investment. And your payback period would have been less than 2 years. Your worship, by illustrating this, is the reason why that internal memorandum, I put my signature to it because I was asked from an expert point of view, dealing with this type of matters or investments, similar investments in the past, in my history of employment.
Mr. Willemse, I think you may ask for a short adjournment. When I come back, I just want to deal quickly with the aspect of what was actually sold and put on record the amount. And then I want to move over to charges. If you just maybe take a 10-minute break. Maybe we can reconvene at 5 minutes past 12. Mr. Willemse, or accurate, sorry.
It's in order, Your Worship.
We may then adjourn and resume at 12:05.
Guys,
study was only done for 10 years.
Correct.
Reason why?
Because that is the years that was actually 9 years that was left of the Enercon Modva supply agreement.
Okay.
Which means after 2031, the assets would be transferred back to Modva, because as per Enercon's, because remember, the assets, NAMCOR Trading bought the rights, the title and interest into these assets for a period of 9 years.
All right.
So which means the model proves that it was only done for 9 years, where after the obligation to transfer it back to the Ministry of Defense would then occur after 2031.
Now, the asset purchase agreement appears in bundle 2, Your Worship, on page 253.
You may proceed.
Thank you, Worship. Now, you mentioned something that, first of all, let's go to page 254. These assets were bought for, what's the amount?
For 53,212,000 Namibian dollars.
That amount is based on what?
That amount is based on the asset valuation that was done by the internal NAMCOR engineering team.
In addition to 1.2, it also reads that an amount of 35 million of the purchase price shall be paid by NAMCOR Trading to Enercon by electric transfer of Enercon's nominated account as follows. Why is there two amounts?
Two amounts?
There's a 35 million and there's a 53 million.
Yeah, the 53,212,000 Namibian dollars, Your Worship, is the purchase price for the rights, interest and title into these assets, which we call bulk fuel storage facilities. The 35, if the Worship can recall, on clause 4.5.1 of the fuel supply agreement signed on the 16th of March 2022, it was mentioned that any debt owned by Enercon would be then recovered or need to be repaid to NAMCOR, utilizing out of this asset purchase agreement.
Okay. So
just to, Mr. Isak, just to repeat that again, the 35 million is for?
It's the debt owned by Enercon to NAMCOR for fuel purchases needs to be basically offset, or they need to pay it back out of the proceeds of this asset acquisition. So which means the 53 million was paid, and then Enercon need to pay 35 million back into their debtors account.
Meaning that at the point of the payment, you're saying that Enercon was in debt to NAMCOR for 35 million.
Correct, Your Worship.
Was that done, as far as you know?
That was done, yes.
So for what was the 35 million paid? Was it just for the debt, or any other money was paid?
Yeah, Your Worship, initially, as per the internal memo, there was an agreement, or it was motivated by the sales and marketing team, that only 25 million needs to be paid back. But then, at the time of this agreement concluded, I believe a decision was made, or recommendation, that 35 million needs to be paid back rather than the 25 million. And then once the 35 million was paid back, so NAMCOR increased this payback to 35 million. So then I believe the sales and marketing team, in conjunction with the finance team, then decided to paid 30 million into the operational account. Enacon had 3 accounts, Your Worship. One account was a debt that was ceded by EcoFuel to Enacon somewhere in March, which I wasn't privy or party to.
A debt of 73 million was ceded from where?
From EcoFuel Investments to NAMCOR, to Enacon to NAMCOR.
So Enacon would then owe NAMCOR this first 73 million?
Yes, correct.
Okay.
That was moved to a debt recovery account which was approved by the board of directors of NAMCOR. And it's also noted in the session agreement. Then there was an operational account, Your Worship. An operational account which was they were trading on. They had 2 operational accounts. One was for the Ministry of Defense supply, and the other one was supplied to the NWR, the Namibia Wildlife Resorts.
Namibia Wildlife?
Resorts. So when the 35 million was paid, a decision by, I was not party to, but I understood that 5 million was paid into the debt recovery account, and then also 30 million to the operational account of Enacon. It will also become evident that Enacon's credit limit, which I already testified that credit limits can be increased or decreased, but in terms of the anomaly, was 15.5 million. So that would have bring Enacon's debt owed to NAMCOR to 5 million after the 30 million was paid. Which means they were then, at that point in time, below the 15.5 million credit limit. And the debtor recovery account would have been reduced from 73 million with 5 million to 68 million. Because one of the rationale, as I understood it, Your Worship, because like I mentioned, I don't deal with customers, was to try and recover as much money to reduce the debt owned by Enacon.
All right.
And by procuring these assets, you actually also reduce, it was also a debt reduction exercise to procure and own assets for 9 years, which you are going to recoup your investment in 4 years and make a double your in the 9 years, and get the chance to reduce your debt.
Mr. Willemse, you keep on telling this court that was bought by NAMCOR is referred to as title, right, and interest.
Correct.
What is that?
Your Worship, in the industry, there is, you can buy the assets, you buy the title, which is basically the ownership, the right to use that assets, and the interest in those assets. So that is basically for that period. And this is not something unique in the industry. And the Enacon transaction with NAMCOR is also not unique. NAMCOR has done similar transactions in the past. If I need to elaborate that, I can do that.
With whom did they do it?
The first one where I was involved in was in my first employment with NAMCOR in 2008. So in 2010, NAMCOR acquired or won a tender from the Langer Heinrich mine, uranium mine in Swakopmund. So when NAMCOR was successful in the tender bid, they had to invest in tanks, pumps, and the related piping equipment. And I think it was somewhere between 15 and 20 million. I cannot recall at the point in time. So on the mine's premises, NAMCOR had to put up these tanks in order to supply the mine. And also a DCF was done to ensure the profitability to NAMCOR trading. But there was, what is significant there is, after the supply period, the tanks will be transferred, the ownership of the tanks from NAMCOR Trading to Langer Heinrich Uranium Mine.
For how much?
For zero.
Nothing.
For nothing. Because you have recouped your investment, because during that period you recoup your investment and make profit.
I see.
So, but there was additional clause, just to protect NAMCOR, that we have put in at that point in time, is a volume clause. That in the event that the volumes that they projected to pump through the sites did not materialize, the contract will be extended until such a time the volume will materialize, so that NAMCOR is ensured that they will make profit and recoup their investment. However, if the volume occurs or was reached prior to the initial contract deadline, that tanks and pumps will be transferred at that point. So if it was for 10 years and the volume was higher than was anticipated, and you reach in 8 years, your volume target to recoup your investment and make money, it will be transferred on 8 years. If it was not 10 years, then it will continue until it reached there. And that was one example, Your Worship. The other example was the Husab uranium mine, Swakop, which we call Swakop uranium mine, where NAMCOR won the tender, and then the assets that was on the mine site belonged to Engine, Namibia. So Engine was the previous supplier to the mine. NAMCOR won that bid, and NAMCOR had to negotiate. There's two options. Either Engine had to remove the assets from the mine, or they engaged with NAMCOR for NAMCOR to buy them out. Obviously giving a environmental clearance baseline. So NAMCOR procured that for around 35 million. But there was a similar clause that at the end of certain volume considerations and time, the assets will be transferred. So to come back to the Enercon transaction, is that it was not new that once you have the right to supply for a period, you can sell the remaining right or interest in those assets during the period that your obligation is not yet fulfilled with the Ministry of Defense, as long as at the end of the 2031, the Ministry of Defense gets the assets.
Okay. So, in this case, you had a 10-year plan, or around about 10 years in the 9 years plan, and recuperate the money. Other than putting your signature on it and supporting the numbers making sense, did you do anything else?
No, Your Worship. I think I might have reviewed, but I think so, that prior to once the MD has approved the transaction and it went to legal, there might be, I cannot recall, as I mentioned to the worship, that I might have had sight of the asset purchase agreement for inputs, but like I said, that was then all that I was involved in this.
Did you authorize the purchase?
No.
Of the asset?
No.
All right. You are charged with, I think, around 11 charges. How do you intend to plead to these charges?
I'll plead not guilty to all of the charges as.
The charges also have alternatives to these charges. How would you plead to the alternative of these charges?
Not guilty, Your Worship.
All right. Now, I specifically want to deal with the charges now. Is there anything else you would like to say about the asset agreement?
In terms of the asset agreement, just to note, Your Worship, and I think it's the letter that Enercon wrote to NAMCOR regarding the debt. And yeah, I think it's on page 199A.
199?
A.
Yes. Just a moment.
You may proceed, yes.
Thank you. Yes, we are on page 109, capital A.
Okay. Your Worship, if you can look at it's a letter from NAMCOR addressed to NAMCOR Acting Managing Director, Mr. Shiwana Ndiyema, on 17th of July 2023, which is basically a year after this asset acquisition. The first,
Just what is the letter about, Mr. Willemse?
the letter is about NAMCOR and NAMCOR contractual matters and NAMCOR's revised debt repayment plan. And why I bring this to the court is because I was in the meeting. I was asked once again, the acting MD felt that I need to sit in with the trading board while discussing this debt repayment plan with NAMCOR.
Who was the acting MD at that point?
Mr. Shiwana Ndiyema.
All right.
And the trading board consisted of Mr. Engelhard Kongoro and Mr. Tim Ikanyo. So, if I can read the letter. Reference is made to the above matter in the meeting of 17th July 2023. We wish to confirm that NAMCOR is committed to resolving the issues arising from the said meeting as follows. The asset purchase agreement. It is noted that there are differences in the interpretation ascribed to the asset purchase agreement dated 15 July 2022. As a way forward, NAMCOR proposes to have a cancellation of the agreement by mutual consent, and NAMCOR is reimbursed the amount of 53,212,000 as a once-off payment. Your Worship, a year after, and after NAMCOR has used the tanks, also contrary to testimony that NAMCOR received nothing. Because if NAMCOR received nothing, when the debt, the 35 million of the 53 was paid in July 2022, NAMCOR had at December 22 or November 22 a debt again of 35 million. So how did NAMCOR reach that debt of 35 million if there was no use of the tanks and no ownership? So I'm not. Fuel was delivered into the NAMCOR tanks, and NAMCOR was the agent then that supplied, because through those tanks you need to, in order to recoup your investment, you need to use that tanks to supply to the ministry, and that's why NAMCOR had the use of those tanks. However, what is important, Your Worship, is the debt repayment in number 2. And I mentioned to this court that there was 3 accounts. And on 2.1, NACAS 2 was the debt recovery account. Your Worship, you would see that the 73 million that was ceded in March 2022 and the 5 million that was then paid in July as part of the 35 payback brought it to 68. But there was additional payments from NAMCOR because there was an approved payment plan by the board of 500,000 a month on this account.
You mean on the debt recovery?
On the debt recovery account.
Approved by which board?
By the NAMCOR main board.
When you say NAMCOR main board?
Holdings board. So you see, Your Worship, the debt reduced to 65 million. So there was, they honor that approved payment plan. But they propose a repayment where they say in the table, NAMCOR continues with monthly payments of $5,000 to be reviewed upwards after 90 days. So they were willing to then, at that point in time, increase the repayment towards this debt. So what they were saying, next payment...
Maybe
Sorry.
just to ask the relevance of this, maybe in...
NAMCOR said they want narrative here is that Mr. Willemse caused NAMCOR a debt, a loss of 108 million in terms of NAMCOR.
Okay, maybe Mr. Willemse, you can explain?
Yes, Your Worship, there was a debt, an existing debt. Now, one of my charges is saying that because of my involvement, I caused a loss by increasing credit limit, and because I was gratified or I received gratification, and NAMCOR then had a total loss of 118 million, or 108 million. So I want to portray to the court that by reading this, first and foremost, I wasn't part of the 73 million, and it was board approved. And there was a payment plan also board approved. Then the operational account, I want also to deal with it, so that when we get to the charges, so that the court have an appreciation of was I involved, not involved, and we will deal with the gratification issue.
But let me just first deal with the session. I'll try to deal with the second part in the charges. If I understand you correctly, that there's a 73 million that was ceded, of which you're not part of negotiation, board approved.
Correct.
So you cannot be involved in any way in that amount.
Correct.
Okay, let's park the other one there.
Okay,
We'll come back to that.
the second one, if I may, which I just want to make a point that the 35 million that was outstanding, which was alleged that I played a part in the debt, in this debt, is Enacon approached NAMCOR with a repayment plan of 5 million, which they say Enacon payment of 5 million to trigger trade against this payment, i.e. NAMCOR grants Enacon value of petroleum product stock equivalent to 5 million. Then Enacon pays an amount of 5 million to NAMCOR specifically for debt reduction. No stock is awarded. Then item A and B under 2.2 year in above is repeated for periods September, October, November, December, January and February 2024, 7 months times 5 million on debt reduction. So what I'm trying to say, Your Worship, is Enacon in 2023 proposed that we will repay this debt to NAMCOR. We'll pay, you give me $5 million of fuel from the 1st of the month, and on the 14th of the month, we'll pay in cash. The second part of the month, you give me $5 million of fuel. Till the end of the month, I pay you 5 million again. Then I also pay 5 million addition to reduce the debt. So by end of February 2024, Your Worship, this debt of 35 million would have then been recovered. However, the board rejected it. If the Worship can move just over 2 pages over to page 199, capital D. The response 2 months later. Imagine you get a letter on the 7th of July, Your Worship, and you get a response 2 months later whereas if you would have received or approved this payment plan, you would have already recovered 10 million. However, 2 months later, the date is just wrong, but if you know the date is right. On 5th of October 2023, a response from NAMCOR just talked about the 53 million cancellation of the asset, but just on page 199E, it's just 10 and 11. Furthermore, Enacon is reminded, and how I know the board has rejected the repayment plan, that they could have in February 2022 recovered the money. So when you as a board or as management and a debtor comes to you and say, I want to repay, and this is how I repay you, and you reject it. Now you want to come 2 years, 3 years down the line and blame staff. Isn't your duty to recover your money first? Then you go to the arbitration clauses in the contract. But NAMCOR couldn't go there because this repayment plan would have then come forward to the arbitrator. And they might have ruled that first give a chance to recover your debt. They went straight to the civil court, which is currently Eastwood, and then they made a criminal case out of this, where a legitimate commercial transaction is now criminalized.
I see.
Because a profitable one. And if NAMCOR didn't know what to do with the things, they could have just made an arrangement, because one of the arrangements they could have made, Your Worship, is engage ENACON and the Ministry of Defense and say, since ENACON, we supply ENACON through you and we have procured these things for the remainder of the period, can we not continue supply, but instead of you paying ENACON for the fuel, you pay NAMCOR directly, and we will give ENACON's margin after agreeing with ENACON what is the payback. Then that would have been in the best interest of the trading company. Isn't that a plausible option? But if you just blatantly deny someone to repay your debt, and 2-3 years down the line you blame staff members that was acted in, not in their individual capacity, but in the capacity as employees of a private company.
Okay, so at this point in time, you were a consultant? No.
No. At this point in time, I was, since 1st of June 2022, I was permanent relation.
And
Just if I understand you correctly, your conclusion is that NAMCOR had no intention to recover it.
No, if they had intention, they would have at least allowed, because one of the questions, the trading board.
Question. That's my only question, Mr. Willemse. I want to deal with the charges now, please. I want to go to, I don't know if you are in possession of the charges, Mr. Willemse.
No, I am not.
Right, I see we can give you a copy, but let's start with count 10. We're losing some sunlight. You don't have a copy of the charges?
It is in my first bundle, but I left it.
Okay. All right, I'll try to go through them, read them to you, and then ask you specific questions. Count 10 is you are charged with corruptly accepting gratification or giving gratification to an agent in that the period March 2018 to May 2023, you're being employed by NAMCOR as a supply logistic manager wrongfully and unlawfully, did directly receive a gratification in the amount of 3,010,000 from ENACON Namibia Limited and Irongo Petroleum CCS gratification for having authorized the supply of fuel above the credit limit. It's a very simple question. I have two questions. Did you receive directly from ENACON Namibia $3,010,000?
No, Your Worship.
Did you receive from Irongo Petroleum CC 3,010,000?
sorry, Mr. Isaacs, are you referring to the count 8?
Yes, I think the amendment is now count 10.
If I'm seeing here, there's a cross and it says instead of count 10, it's count 8.
I agree, because there was a wrong numbering because of the manner in which the charges were drafted. They were drafted in a hurry, actually. That's why there are some typos, but they were actually rectified. But it's actually count 10, because Your Worship will recall that from page 4, it's count 7. So therefore, by going to the next page, then the next count will then be count 8, not 10.
Okay.
So it should actually be count 10.
It should be count 10 or 8.
Count 8, my apologies. Yes, count
All
8.
right.
It's the same count. I have count 10. Maybe I can just liaise with my colleague to
Yes.
get the numbering correct and then deal with it after 2.
Okay, yes, the numbering has changed. If you can just deal with the ones that I have. In terms of the charge sheet I have, there have been a few amendments. There's no signature. I'm not sure if it's the state or who. I'm not.
It's actually the state. We renumbered them when we noticed that the numbering was not in sequence.
Okay.
Yes.
We just want to get clarity. The numbering as on the charge sheet that you are in possession of, are those the correct numbers, if I understand my colleague correct?
Yes. Yes, indeed so.
Can we just then maybe break and just compare mine of what I have, and then just make my corrections and then deal with them as per it appears on the charge sheet.
Okay. Okay, we will then adjourn and proceed at 2:15
As a
for continuation of the bail application. Accused is remanded in custody.
Well, guys, Your Worship, can I just suggest my apologies that maybe Mr. Isaacs has your copy
Yes.
if it's in order. Just for
I'll
him to
provide
rectify it.
the,
I'll make a copy. I'll make a copy if I can have
Yes.
the correct one.
the charge sheet is unavailable.
As a copy.
We may adjourn.